Hi, I'm attorney Tim Baldwin, founder of Property Management Law Solutions. I'm going to talk to you briefly about an issue that I addressed in another video and article. The issue that we're talking about is when a tenant gives a landlord a 7-day notice to cure a default, particularly a default that has to do with the warranty of habitability or with violating a provision under Florida Statute 83.51, subsection 1. If the landlord receives a notice from the tenant to cure a default under Florida Statute 83.51, subsection 1, then the landlord really needs to do a few things. And if you're a property manager, this is specifically to you. First of all, you need to contact the property owner and inform them that the tenant has given this 7-day notice to cure. Inform them of what the items are that the tenant has claimed the landlord breached. For an example, a leaky roof, or mold infestation, or termite infestation, or whatever the particular item may be. Next, the property manager needs to make sure that the property owner is on the same page with addressing the real issues in the legitimate claims from the tenant. Next, the property manager needs to contact a contractor to inspect the property and each and every item that the tenant has listed in the notice to cure. Some of the items that the tenant has listed may not actually be a default, or may not fall under the warranty of habitability, or may not fall under Florida Statute 83.51, subsection 1. If in fact the items do fall under the warranty of habitability or Florida Statute 83.51, subsection 1, then the landlord needs to address those right away within the time period of the notice, namely the 7-day notice to cure. After the contractor has inspected those specific items, the contractor needs to get back with the property manager and inform the property manager of what needs to be done, what the cause of the items or the defects were, how long it's going to take to repair, and what the cost of the repairs are. Next, the property manager needs to relay that information from the contractor to the property owner and get authorization to make the expenditures necessary to put the house back into a warranty of habitability and also to comply with Florida Statute 83.51, subsection 1. If there are any items that don't fall under the warranty of habitability or Florida Statute 83.51, subsection 1, there needs to be a response appropriate to that, essentially identifying those and letting the tenant know that those don't fall under that warranty of habitability or the obligations, and therefore the tenant cannot withhold rent because of those things. However, if the statute or the lease require the landlord to remedy those problems, then they're going to have to still remedy the problems, but the tenant can't withhold rent for the landlord's failure to fix those problems. After the contractor and the property manager have identified the items that do fall within the landlord's obligation, then the landlord and the property manager need to make the specific arrangements to have those items repaired. Also, the property manager needs to keep the tenant informed of what's going on with the repairs, just in case there are other issues that need to be addressed. For example, a tenant may need to vacate if the property needs substantial work done, or perhaps you need to exterminate pests or rodents and those kinds of things. There may be a period of time where the tenant actually has to vacate the property for the benefit and the welfare of the tenant. During that time, the landlord has to consider whether to abate that rent or not. If the landlord remedies these problems within the 7-day notice to cure period, then the tenant cannot continue to withhold rent. They have to pay rent as soon as those repairs are done. If the landlord does not remedy those problems within the 7-day notice to cure, then the tenant could actually withhold rent if those obligations of the landlord fall within the warranty of habitability or Florida Statute Chapter 83.51, subsection 1. If they do not fall under those obligations, then again, the tenant cannot withhold rent. And if the tenant does withhold rent, the landlord could file an eviction for non-payment of rent. If the landlord does not want to repair the items that fall under the warranty of habitability or Florida Statute 83.51, subsection 1, then the property manager is really faced with the decision of whether to terminate the relationship with that property owner. If the property manager decides that he is going to terminate that relationship, then simply the property manager needs to give the property owner notice of the termination of the property management agreement and state the reasons why. I hope this information was helpful for you as a property manager or a landlord. Again, Property Management Law Solutions is here for property managers. Check out pmlawsolutions.com. I'm Tim Baldwin. Thanks.